Hi, my name is John Gudgel, and I'm a second-year PhD student at George Mason University School of Public Policy and Professor Ruth's teaching assistant for this course. Today I'm going to talk about what I call the Internet Privacy Policy Paradox. So what is the Internet Privacy Policy Paradox? Well, we all want to be able to get optimum personal search results when we use a search engine like Google. And we are willing to share vast amounts of personal information through social media such as Facebook, YouTube, and Twitter. On the other hand, we are also concerned about our individual, family, and national security, and shocked when our personal privacy is violated by either the government or internet companies. Internet privacy concerns have been in the news quite a bit this past summer. From the exploits of Edward Snowden and NSA Gate to concerns in both Europe and the US about how Google and other internet companies are collecting and using personal data, there is a growing sense that our right to privacy is being infringed. And at times there appears to be little that Congress can do to protect our privacy rights. Which brings me to my research question: are U.S. laws adequately protecting individual privacy in an ever-evolving digital world? I'm going to examine this question from two perspectives and two specific laws. The first perspective is looking at government invasion of privacy and the protection afforded by the Electronic Communications Privacy Act of 1986, or the ECPA. The second perspective is looking at corporate invasion of privacy and the protection afforded by the Consumer Privacy Bill of Rights, which was proposed by the Obama administration in 2012. But first, what is privacy? First, you should know that there is no explicit mention of privacy in the Declaration of Independence, U.S. Constitution, or the Bill of Rights. The right to privacy has been debated in over 700 Supreme Court cases, usually citing either the First Amendment right to free speech or the Fourth Amendment prohibition on unreasonable searches. This particular discussion was discussed by Supreme Associate Justice William O. Douglas in 1952, when he stated that the right to be left alone is indeed the beginning of all freedom. Probably the most cited reference on the topic of privacy is a Harvard Law Review article written by Harvard Law professor Samuel Warren and future Supreme Court Justice Louis Brandeis, entitled The Right to Privacy, which was published in 1890. In that article, privacy was defined as the right to be left alone. Ironically, that article was written in response to perceived threats to privacy brought on by the invention of new technologies, including the telephone and the consumer Kodak camera. A copy of this article is posted on Blackboard. Which brings us to our technological change, the Internet. It's hard to believe, but the Internet is less than 25 years old. My starting point for the birth of the Internet is in 1989, when Timothy Berners-Lee, then a research fellow at the CERN laboratories in Switzerland, conceived of the World Wide Web and created the first web browser. Since that time, we've seen the creation of many commercial web companies such as Google, the evolution of new social media companies such as Facebook, and the spread of new interactive web applications. When thinking about internet privacy, there are a few things you need to know. First, the business models of many internet companies rely on the collection and use of private information. They collect this information through cookies and social media, and then they provide you targeted search results and targeted advertising. They view the private information that they collect from consumers as their product that they can sell to the ad companies. The second thing you need to know is that the internet is in the public domain. Information that you freely provide on the internet is not protected by most privacy laws. Third, private and public entities are becoming increasingly able to link private information with a specific person. This can enable things such as internet theft, various other types of cybercrime, and enables government surveillance, and also allows for the spread of possible erroneous information about a particular person. Let's look at internet privacy invasion and erroneous spread of information. On the internet, we have information that we have freely provided through social media such as LinkedIn, Facebook, or Twitter, as well as useful information that others have placed there, such as articles that we have written or activities that we have participated in. We also know that incorrect, confusing, or harmful information can also be associated with our names. There can be many instances of people with our name around the United States. And this information can imply to us different types of race, different sex, that we are younger or older, that we might be a criminal, or in some cases that we might be dead. So what laws protect our internet or digital privacy? Well, there are many laws on the books protecting our privacy. It is interesting to note that the timeline of this legislation, much of it was created before the internet became publicly available. This includes the Electronic Communications Privacy Act of 1986, the preeminent law protecting government intrusion into private electronic communications. Also, much of the legislation created since 1989 is much more incremental, focused on specific aspects of privacy, such as health care, or empowering government intrusion into our privacy for reasons of national security. Let's look first at the Electronic Communications Act of 1986, or the ECPA. Enacted in 1986, prior to the internet, it was enacted to protect a new form of electronic communication, email. The sponsor was Senator Patrick Leahy, and it gave warrant court protection to private emails on a person's computer, emails that are in transmission, and also on open emails which may be stored by a service provider for up to 180 days. Emails that are received by a remote person, opened after transmission, or stored by a service provider for more than 180 days do not have warrant protection. Recognizing the changes due to the internet, Senator Leahy, still in office, has proposed modernizing the ECPA to give full warrant protection to all non-public personal data stored by service providers, including internet companies, for an unlimited period of time. In one of those strange paradoxes that I talked about earlier, we see forces both from the extreme right and the extreme left uniting in support of this bill. In this case, Grover Norquist and the American Civil Liberties Union. Here you have another paradox: internet companies who are collecting the data uniting to protect the privacy of data from government intrusion, even though they intend to use this private data themselves. A second bill of interest is the Consumer Privacy Bill of Rights, introduced by the Obama administration in 2012. When it was announced, it was trumpeted as the Obama administration's blueprint for privacy in the information age. It introduces the concept of Fair Information Practice Principles, or FIPS. Under FIPS, an individual will have control over the information that's collected and when it is used. They would also have transparency to that information and understand why it is being collected. And also information will be collected that is in context to the purposes of the website. Web collectors will assure the security of the information that is being provided and allow access to that information so that personal data errors can be corrected. The focus will be on reasonable limits to data collection, and all internet companies or all companies collecting private information will be held accountable. The enforcement will be by the Federal Trade Commission, and the focus will be on self-regulation by internet companies. Once again, we have a strange paradox, such as the uniting of defeated presidential candidates in support of this bill. In another strange paradox, internet companies and privacy groups are lined up on both sides in support and opposition to this bill. So in answer to the research question, are U.S. laws adequately protecting individual privacy in an ever-evolving digital world? The answer is probably not. But it is unclear what the proper path might be. This is especially true in light of changes to the internet that are taking place right now, such as the spread of mobile internet technologies, the availability of unlimited internet addresses through the recent deployment of IP version 6, and the coming Internet of Things, where most everything you own or anything that you could run into could have an internet address. This will be the topic of my next presentation. So, thank you for listening today, and let me know what you think through your